Hello and welcome to another episode of Crime Courtroom Confidential. I'm your host and I am a Crown Prosecutor in the UK, dealing with Crown Court cases. So it's the more serious end of criminal cases that we have in the UK judicial system. So today I would like to talk about Annabel Rook. This case involves themes of domestic abuse, coercive control, and I want to make sure that everybody is aware of what is going to be discussed. If it is too triggering for you, take a break from it. We can see you on the next episode. But this case, anybody, regardless of race, religion, or socioeconomic background, can fall victim to domestic abuse. Even those people who work directly with vulnerable women who have been harmed at the hands of men are not immune to coercive control and domestic abuse. And that fact is central to this particular case that we're going to look at today. A woman spent her entire life helping others. She was the co-founder of MamaSuze, which is a charity designed to support vulnerable women. And she was in a relationship with a man who she realized had become unsafe as a partner. She was trying to separate, and she was trying to manage that separation really carefully because she knows, because this is what she does for a living, that is the most significant period of time when risk escalates, when you're trying to leave. And there's reasons for that. But in the early hours of one June morning, she was killed. And that exposed one of the most dangerous truths about domestic abuse. That leaving can be the moment of the greatest risk, and that nobody is immune to being groomed into accepting a relationship that is dominated by coercive control and domestic abuse. That woman was Annabel Rook. We're going to look at her case through the lens of a senior Crown prosecutor, the law, what the law had to prove, why manslaughter was not enough in this case, and how this case fits with a wider pattern of coercive control, separation risk, and domestic homicide. And sometimes, in the face of that escalating risk, professionals, police officers, friends, family, we need to ensure that we play the long game, whilst identifying the increasing risks, identifying the patterns of behaviour, and then creating and offering a safety plan, a safe, reliable place with no judgment, being everything that that perpetrator is not to that woman. And of course, it can happen to men, but statistically speaking, this is a gendered topic, because in the majority of cases, the perpetrator will be a man, whether that is against a woman, against another member of his immediate family, or against another man that he's in a relationship with. It, generally speaking, tends to be men who are the perpetrators. There are some women, and interestingly, we'll talk about this a little bit later on, the women who are domestic violence perpetrators follow the same route to domestic homicide. There are the same stages. And we're going to talk about the stages of homicide as well. So I'm just going to pull up some photographs so that you can look at something more exciting than my face as we're talking. So this is just a range of photographs. This is a house after the incident occurred. Because not only did Clifton George try and, well, he did kill her. Not only did he kill her, he tried to hide all the evidence by setting the house on fire. So let's talk about what happened in the early hours of the 17th of June of 2025. So it's only last year. It's a newish case. Emergency services were called to a house in Stoke Newington, that's in North London, because there had been an explosion. There was smoke, there was shattered glass. The neighbours were frightened. They'd heard this happening and they contacted emergency services. But that scene that they arrived to, it wasn't just an explosion. And it was a scene that very quickly became something far darker than a domestic fire. Inside that home lay Annabel Rook. She was a mother, a daughter, a sister, a friend, and she was a charity founder. MamaSuze, named after her wonderful mother, Susanna, and a woman whose working life had been dedicated to helping other women and children recover from displacement, trauma, and gender violence. She'd been stabbed 31 times by the man who had been her partner for more than a decade. 31 times. Do you know how many times it takes to stab and kill a person? Once. So when you hear people, professionals talking about kill, well, this is an example of that. This episode isn't about what happened in that house. It's about what the Crown had to prove, what the defence tried to argue, and why the jury was sure that this was a murder case and not a manslaughter one. And why domestic abuse should never be treated as background noise in a murder case. It's the central point. So Clifton George is the and he pleaded guilty when he was charged with manslaughter and to arson being reckless as to whether life was endangered. Generally speaking, two versions of a manslaughter, an arson charge. There is arson, which is, and there is arson with the intent or recklessness as to whether life was injured. And that is basically, you started a fire somewhere that either you knew or ought to have known there was a real risk to people's lives. And when you think about a residential property, of course, often that will be a case where there is that life is endangered. Part of this is that he denied murder. So he pleaded guilty to manslaughter, which is an alternative charge to murder. So they can enter a plea to an alternative. Of course, the Crown don't have, in this case, they didn't. But his case was he had lost control. So back in the day, this was very regularly a phrase that was used. something that happened in the heat of passion, or she pushed into the control. It is very rarely the case that homicide in because through an intentional killing carried out with rage because he had lost control. He had lost control of Annabelle. After a history of coercive and controlling behaviour within the relationship, at the point when Annabelle was trying to end the relationship, sorry guys if that was still recording and I was pulling faces, it threw me out of StreamYard, so just bear with me one moment. Let's reopen the photographs, because of course I want you to have something interesting to look at. The jury at Snaresbrook Crown Court unanimously convicted him of murder, and the judge imposed the only sentence that the law in the UK permits for murder, and that is life imprisonment. But he then had to decide the minimum term George needed to serve before he would be eligible to apply for release. That term in this case was 23 years, reduced by the time that he'd already served on remand waiting for the trial to happen. For the arson, he received 6 years, but that was to run concurrently. And in the UK, the way that sentences work is slightly different to those viewers who are based in the US and other countries. So what the overall sentencing guidelines provide for is that, generally speaking, you will make an upward adjustment for the totality of the offending on that particular occasion, but then run the sentences concurrently. And the idea is that because all of these offences relate to the same set of circumstances, that you don't over sentence or double sentence for the various elements of the crime. So 23 years for the murder, 6 years for the arson. They run at the same time, but that 23 years will have been extended a little bit from where the judge was initially thinking of placing that tariff, to take into account the full extent of the offending. In England and Wales, murder is committed where a person unlawfully kills another human being, intending either to kill that person or to cause them really serious harm. And the burden for proving that offence rests on the prosecution throughout. The standard is the criminal standard in the United Kingdom, which is that the jury must be sure beyond a reasonable doubt. Not suspicious, not persuaded on balance, but 99.9% sure about every single element of the offence. Here, Clifton George didn't dispute the act of killing. He accepted that he had killed Annabelle. The central question in this case was his state of mind. So did he intend to kill her, or at least to cause her really serious harm? The evidence was stark. He punched, he strangled, he paused, he moved to the kitchen. He retrieved a knife. He returned to Annabelle and he repeated a stabbing motion very many times. There were 22 wounds to her body created by the stabbing and 9 further defensive wounds inflicted by the knife on her arms. So she fought for her life. And some of the injuries that she sustained were inflicted after her collapse, and that plays a big part in terms of what was his intention. And did he have time to stop, think about what he was doing, realise what he'd done, and actually stop and potentially save her? We don't prove intention by opening a window into the defendant's mind. We prove it by inference from what the person did, what they said, what they used, how long it went on for, where the blows landed, what they did before, and what they did afterwards. On the Crown's case, this was not a chaotic loss of temper. It was sustained lethal violence following a strangulation in the context of anger at Annabelle's attempt to break free from his control and achieve her own independence. So why was manslaughter not enough in this case? The defence sought to rely on loss of self-control under sections 54 and 55 of the Coroners and Justices Act 2009. It made out that if made out, that partial defence does not acquit the defendant. It reduces the offence from murder to manslaughter. But it is a tightly controlled statutory defence. So it isn't as simple as saying, well, I lost control. I was angry, I lost control. I didn't know what I was doing. The law requires evidence of an actual loss of self-control, a qualifying trigger, and then an objective assessment that a person of the defendant's sex and age, with a normal degree of tolerance and self-restraint in the same circumstances that the defendant found themselves in, might have reacted in the same way. It is not enough for a defendant to simply say, I snapped. It's not enough that he was angry or that he says that this was in the heat of passion. It is not enough that he felt rejected, humiliated, or aggrieved. Incidentally, domestic intimate partner homicide is almost never in the heat of passion. These offences are usually thought about, fantasised about, and planned, and they follow a really clear timeline according to extensive research done by a range of experts worldwide, but we're going to look at one particular expert from the UK shortly. The judge in this case concluded that insufficient evidence to ensure that the defence could safely be left to the jury. So the judge essentially took that off the table and said, no, you can't put that defence before the jury. That's legally significant because it means that even taking the evidence at its highest from the defence perspective, the statutory route from murder to manslaughter was not available to this defendant. So the remaining issue was intention. And this jury, they were sure. This point matters profoundly in domestic homicide cases. Perpetrators, they often try to narrate lethal violence as emotional overwhelm, a moment of madness, flash of temper, unbearable provocation by the wife that has been driving them crazy for so long. But the law asks a much sterner question, which is, was this truly a loss of self-control within the statutory meaning, or possessive violence by somebody who could not tolerate the victim reclaiming their autonomy? And that brings us to the context without which this case can't be properly understood, and that is domestic abuse and coercive control. Domestic abuse and coercive control, they're not merely a relationship gone wrong or a difficult relationship, or as I sometimes hear people referring to, a toxic relationship. There is no such thing as a toxic relationship. There are toxic people. Under the Domestic Abuse Act of 2021, it can include physical or sexual abuse, violent or threatening behaviour, coercive and controlling behaviour, economic abuse, psychological abuse, and emotional abuse. The parties have to be personally connected, so this isn't just intimate partners. It includes anybody who is within the definition of personally connected, and that includes close blood relatives, any relationship where there is either a current or past intimate relationship. So it doesn't have to be the case that you're in the relationship with the individual at the time, because often we see that domestic abuse and coercive control, they exponentially increase after the person has left the relationship. It can also include people who are in a relationship where there is a carer and cared for person. And there is more to that list, but essentially it's people who have a strong personal connection. And the law recognises that abuse is sometimes one incident, but it is often, more times than not, abuse that is a course of conduct. In Annabelle's case, witnesses described Clifton George's anger, his volatility, his humiliation of Annabelle, his gaslighting, his body shaming, and his outbursts about trivial things. And these all fall within the standard things that victims of domestic abuse will report as happening to them. Annabelle had spoken to people of walking on eggshells all the time around him. She had recognised that the relationship was abusive. In the weeks before her death, she described it as not tenable and feared more wrath to come. Those words matter. They're not hindsight, they're contemporaneous indicators of fear, control, and a risk of escalation. They show Annabelle's own developing recognition of the risk that she was facing and the terrible truth that recognition alone doesn't guarantee your safety. Once you've recognised the position that you're in, you then need to find a way to safely extract yourself from the situation. And that's the hardest part often. To understand why this case matters beyond one courtroom, we need to place it within the wider evidence on domestic abuse and femicide. So let me talk to you about that for a moment. Bear with me, I just need a drink. The Office for National Statistics reported that in the year ending March 2025, an estimated 3.8 million people aged 16 and over experienced domestic abuse in England and Wales. Police recorded 1,350,460 domestic abuse related incidents and crimes, of which 816,493 were recorded as crimes. And even that captures only a little bit of the true picture, because most crimes aren't reported by victims of domestic abuse for very many reasons. The Domestic Abuse Commissioner highlighted that in the same period, the Crown Prosecution Service received 76,393 police referrals for domestic abuse related offences. And that would be a referral asking for a decision about whether or not they can charge the offences. So the police have the authority to charge certain offences, but for a significant proportion of offences, they don't get to decide themselves. They have to put the case forward to the Crown Prosecution Service, who then decide whether or not they're willing to proceed to a prosecution. That decision is based on two stages. The first one is the evidential test. So there's got to be a reasonable prospect of conviction in relation to each of the offences. And the second part of the test is the public interest test. So essentially, is it in the public interest in all of the circumstances of that particular case to actually move forward to a prosecution? Of those 76,393, there were 53,919 that were charged, and convictions were secured in 41,070 of those. So quite a large proportion of the ones that were charged were convicted. That's because there has to be a realistic prospect of conviction when the Crown Prosecution Service look at it. So it weeds out the weaker cases. Unfortunately, just because a case is weaker evidentially does not necessarily mean that it didn't happen, and it doesn't negate the risks to that victim or the impact on that victim of those crimes. But you can see that as you go down the funnel towards a conviction, you get a significant proportion aren't reported. Of those that are reported, only a small number get recorded as crimes sent to the Crown Prosecution Service. It narrows even further when it hits that point, and only so many are charged. And then, of course, a few fall out the wayside. And sometimes that's because, in particular in domestic abuse cases, the victim doesn't want to support a prosecution. And of course, the Crown Prosecution Service guidance on domestic abuse is that we should always try and build a case that we can run without the complainant or victim. Because it is so frequent that people don't feel able, for so very many reasons, to support a prosecution. after they've reported it to the police. And the idea is that if we build a strong case, then it doesn't matter. We can take them out of the equation, we can still get a conviction, and we can protect people. But sometimes without the complainant's evidence, there is just not enough evidence to get a conviction. And that's not through want of trying on the part of the police or the CPS. There's a vulnerability knowledge and practice programs domestic homicide project that took place, and that recorded 347 domestic abuse related deaths in England and Wales between the 1st of April 2024 and the 31st of March 2025. That's nearly one a week. So one person dying because of domestic abuse every single week in England and Wales. I believe that we're sitting at around one per week or just higher for the current year. Now, to our friends across the pond in America, that might seem really low, but if you think about the size of England and Wales, not taking into account Scotland, which has its own separate judicial system, and Ireland, you know, we're talking about a very small geographical area that produces one person being killed every week through domestic abuse. This included 125 domestic homicides and 150 staged or suspected victim suicides following domestic abuse. So sometimes it won't be a suicide, it's just staged to look like that. And sometimes actually it's just that the victim has been pushed to the edge of their boundaries and they can't take it anymore. Across the 5-year period from April 2020 to March 2025, it recorded 1,452 domestic abuse related deaths. So that's the UK, or England and Wales. Globally, the figures were no less sobering. So the World Health Organization and UN partners reported in 2025, falling over my own teeth there, nearly 1 in 3 women, that's an estimated 840 million women globally, have experienced physical or sexual intimate partner violence, non-partner sexual violence, or both in their lifetime. UN Women and UNODC estimated that globally around 50,000 women and girls were killed by intimate partners or family members in 2024. That's about 137 every day, or 1 every 10 minutes. So when you look at it globally and you think every 10 minutes, somebody else dies at the hands of somebody who they're close to, it's quite sobering to think about that. When people describe it as an epidemic, they're not joking. It is, in fact, an epidemic of exponential proportions. These statistics themselves don't make Annabelle just another statistic. They do the exact opposite. They show that her death fits within a recognisable pattern of male violence, coercive control, separation risk, and fatal entitlement. The reality is that whilst men can suffer from domestic abuse, they're far less likely to. Male violence is a gendered phenomena. 80% of intimate partner homicide is by a man against a woman. And not all of the remaining 20% are women against men, as 90% of all homicides are committed by men, whether the victim's male or female. More startling is the fact that the small percentage committed by women included 77% of women reacting to a history of domestic abuse by their partner. So that's, what, 23% of the remaining women who are domestic abuse perpetrators. And that just, it brings into full light exactly how gendered of a phenomenon it is. And I understand there will be lots of people who say, you know, I know a man, or I am a man that has suffered from domestic abuse. And I think potentially the figures are slightly skewed by the fact that men are even less likely to report these crimes because they're embarrassed that they're being abused by a woman. But I don't think that they skew them significantly. So when you look at that statistical background, one of the most important frameworks for understanding the pattern of domestic homicide comes from Professor Jane Monckton-Smith. Now, this lady is one of my favourite sheroes in the world. The research that she has done into all aspects of homicide, in particular domestic homicide and domestic abuse, is unfathomable for one person to have done all of that in one lifetime. Her work on intimate partner homicide has transformed how many professionals understand risk. And her research identified an 8-stage homicide timeline. So, in brief, that is the pre-relationship history of the perpetrator. So usually there is a history of domestic abuse or other violence in their background. Rapid relationship development, coercive control, a trigger threatening that control, followed by an escalation. And sometimes people will cycle through these earlier stages, either within one relationship or between relationships. But sometimes we hit the more advanced stages, which is a change in the perpetrator's thinking, planning, and then the homicide itself. The central insight of that work is profound. Domestic abuse is rarely an inexplicable explosion from nowhere. It often follows a pattern. The model shifts attention away from isolated incidents towards motivation, control, entitlement, a sense of ownership, escalation of risk, and a perpetrator's responses to a perceived loss of control. Applied carefully to Annabelle's timeline, several stages appear starkly relevant. There was a long relationship marked, according to the judge, by controlling and emotionally abusive conduct. There was a trigger, which was Annabelle's decision to separate, to ask George to move out of the home she owned. And his realization that he had no legal entitlement to a share of the property and was beginning to lose control over what he perceived to be his property, and that's not the house that we're talking about, that's Annabelle. There was escalation, so there was an increase in drinking, anger, arguments, violence, strangulation, use of a knife, repeated stabbing, and then arson. So each of those elements of the relationship were an escalation, but then within the incident itself, there is a clear pattern of escalation. Arguing with her isn't getting a response anymore. Violence used against her isn't regaining my control. Strangulation, not regaining control. What can I do next? I can stab her with a knife. I've killed her. What should I do next? I'm going to set the house on fire. I'm going to decimate her. I'm going to decimate the property that I didn't have any rights to a share of. And in that process, I'm also going to hide evidence. There is also arguably a change in thinking. So at the point at which the perpetrator no longer seeks reconciliation or control through normal tactics of coercion, so, after violence, this kind of intense love bombing and apologizing and, promises to change and all of those things that we often hear about. And then there is a change in his behavior and his thinking, because he acts as though the victim's autonomy is an unforgivable betrayal. The evidence recorded his fixation on Annabelle having lied and his disproportionate sense of grievance about that. And in prosecutorial terms, that matters because motive might not be an element of murder, but motive can help us to illuminate what someone's intention was, the context behind their offending, and also to assess the person's dangerousness. Because in any homicide case, and in many others actually, but definitely in a homicide case, the judge needs to assess whether or not that person falls within the definition of a dangerous offender, which would then require an increased sentence. Of course, the most significant of those would be a whole life order, but they are very rarely given. And there, of course, is a practical reason for that, which is that there is absolutely no spaces in any prisons. So if we had everybody who committed homicide on a whole life order, we just simply wouldn't be able to house them. So there's got to be an assessment of the risk that that person poses, the potential for rehabilitation and return to society. But remember, of course, any minimum term is exactly that. It's a minimum term. If that person doesn't get assessed as safe to release, then they won't be released. Whether those assessments are sufficiently carried out and whether the people making those assessments are sufficiently trained in relation to domestic homicide in particular is a whole other story, and I'm not going to delve into that today, but I think it's fair to say that there's room for improvement. But there isn't only the perpetrator's homicide timeline. There's also a victim's timeline, and that is a timeline of separation, hope, and risk. Annabelle's timeline is painfully familiar to those who prosecute domestic abuse. She was trying to manage risk. She was trying to protect her children, to minimize pain for everybody, and to preserve dignity for both herself and for George. She wanted a separation. She wanted him to move out. She considered even offering him financial support with a lump sum of £50,000 so that he could get a place nearby and they could co-parent. She still imagined a future in which somehow the family could remain civil. And that went to the extent of she hoped that they could one day holiday together as a family. So she's really looking at finding ways to minimize the risk and to increase the hope of a safe separation with the minimization of both risk and hurt to everybody involved. But that's one of the cruelest features of coercive control. Victims often plan with reasonableness because they are trying to survive. They soften the landing, they offer reassurance, they try to manage the perpetrator's emotions. They hope that if they're careful enough, kind enough, practical enough, that the separation can be made safe. But often perpetrators will take advantage of those tactics that victims use. Separation is one of the most dangerous points in an abusive relationship. It is the moment when that perpetrator's control of the individual is most directly threatened. In this case, Annabelle's professional life makes that reality even more haunting because she knew about that risk. She worked with women who had suffered harm and trauma at the hands of men. She created spaces for survivors of displacement and gender-based violence. But domestic abuse isn't defeated by intelligence, compassion, professional expertise, or moral courage. Perpetrators manipulate people. They manipulate attachment, children, housing, money, shame, hope, and fear. And they exploit the victim's humanity, something that they don't themselves own. And that's why the question should never be, well, just why didn't she leave? I don't understand it. The better question should be, what made leaving dangerous? And what did the perpetrator do each time she tried? And how can we enable women to leave safely? Violence escalates in stages, even within the fatal incident itself in this case. First, he starts with punching Annabelle. It's pretty standard in a domestic abuser's playbook. it was probably punching in places that people wouldn't see. Then he moved on to something that is a much more significant offence, which is strangulation. And the reason that it has been brought into law as an offence in its own right, non-fatal strangulation is one of the key predictors of domestic homicide within that relationship. He then pauses. It's not working. He's not regaining control. So he escalates. He goes to the kitchen and he gets a knife. He stabs her. It's not enough. He stabs her again. And that repeats over and over again. Then hours later, so he's had time to sit down, cool off, calm down, work out what to do. He attempts to cause an explosion by releasing propane gas and igniting it in the basement. Now that basement, directly under the kitchen, where Annabelle's body lay. And I don't think that was coincidence. The knife also mattered. George did not simply find himself holding a weapon. The judge pointed out that he clearly stopped, thought, went to the kitchen and came back with a knife. In law, that pause and retrieval of a weapon can be powerful evidence of the intention to commit either murder or really serious harm. And that intention, let's be clear, you don't have to sit down and plan out like some serial killers do in a diary or a manual exactly what you're going to do, when, where, and how. It can be formed in the blink of an eye. Even if the killing itself was not premeditated in the longer term sense, if you stop, well, you don't even have to stop. If during that incident you think, I'm going to kill her, or I really want to hurt her and hurt her badly, then that's intention. Non-fatal strangulation, if I just go back to that. The evidence of strangulation before the stabbing is not incidental. It shows domination. It shows risk of lethality. It's very easy to kill somebody by strangling them. It takes a few minutes, but you can very easily, either on purpose or by accident, kill somebody if you are engaging in strangulation. And it's a transition from assault, so I'm hurting this person, to potentially fatal violence. The arson added yet another layer. So the prosecution suggested that it was an attempt to destroy evidence. The judge was sure that George had in mind that blowing up the house would affect the evidence of what he'd done. He was also reckless about whether life was endangered, neighbours in particular, because it was an end terraced house, so all of these houses are connected internally. If he causes a significant fire in one property, it's likely to spread. And emergency responders and other people could very easily have been killed. Once the jury was sure that this was murder, the sentencing framework was clear. So let's take a slightly deeper dive into the sentencing guidelines. In the UK, it isn't a case that judges can just decide to sentence a person for any offence to whatever they choose in terms of punishment. We have sentencing guidelines that provide an overall structure and framework for sentencing processes, but it also contains guidelines for each individual offence, and those guidelines have a number of stages that the judges work through in order to come to the appropriate sentence. Doesn't mean that every judge is going to come to exactly the same sentence for a defendant who's done the same thing in the same circumstances. There is still a range, but it's a range that is available to them as a reasonable sentence for that offence. So for murder, the sentence is mandatory life imprisonment. The real sentencing exercise is in the minimum term, the period that must be served by the offender before they can be released at all, considered for release at all by the parole board. And of course, at that point, release is not automatic. If the offender remains dangerous, he remains in custody. If he is released, he remains on licence for life and can be recalled if he commits any further offences. And that licence is likely to have a number of conditions which help to monitor that individual once they've returned to society. All judges in England and Wales follow the same sentencing guidelines, and these are available on the internet for anybody to read. If you just look up UK sentencing guidelines, you can find them. If you want to look at one for a particular offence, if you put in the offence sentencing guidelines for murder in the UK, it will come up and you can have a look at it. And you can go through that process and see what you would have come to in terms of an appropriate sentence. It provides for the judge to go through a number of exercises. So first, he will look at the seriousness of the offence overall. He will then look at the culpability of the offender and the level of harm caused. And in terms of the culpability and the harm caused, there is then a table which provides the judge with both a starting point and an appropriate range. And when you're looking at that range, the judge considers aggravating and mitigating features, which can either increase or decrease the starting point. The judge approached sentence under Schedule 21 of the Sentencing Act 2020. The starting point in this case was 15 years, but aggravating features substantially increased that minimum term. These included sustained and excessive violence, the domestic abuse context, breach of trust, use of a knife, intoxication contributing to escalation. Shall we try that again? Intoxication contributing to escalation, which often offenders think will explain their actions or mitigate their culpability, but actually it does the opposite. It aggravates their culpability significantly. And then, of course, you have the subsequent arson, which is another aggravating factor, which is why you don't then double sentence by giving a consecutive sentence for the arson. Sometimes there are consecutive sentences, and the guidelines cover when those are appropriate as well. The judge found a few mitigating features, so there was no previous conviction history that was relevant for George, and there were aspects of childhood trauma for George. But those factors were limited in the face of the offending. The judge rejected any suggestion of provocation falling short of loss of self-control and was sure that George intended to kill Annabelle. The life sentence was therefore not simply a punishment for one night of violence. It was the legal consequence of a murder aggravated by a history, an extended history, in fact, of domestic abuse, sustained brutality, use of a weapon, breach of trust, an attempt to destroy the evidence afterwards. Now, my view is that arson wasn't just to destroy evidence. It was a way to exert the final level of control over the remains of Annabelle, and also to damage or destroy the property that he'd found out he had no legal entitlement to any share of. So, what are my reflections on this case as a senior Crown prosecutor? First of all, please, let me say that I don't have any access to any information about this case other than what's in the public domain. So all information that I've considered comes from the sentencing remarks from the judge and also from the various articles that were released in the press at the time. But for me, personally, as a prosecutor, and I have a passion, as I know many of you are aware, for resolving and preventing domestic abuse, domestic homicide, child abuse, and sexually motivated crimes. So for me, this case is a reminder that domestic homicide is not merely a murder that happens inside a home. It is often the end point of a pattern of entitlement, coercion, control, humiliation, volatility, escalation, and separation. The courtroom, of course, necessarily focuses on admissible evidence in relation to that particular offence. Legal definitions, burdens, standards of proof, directions and verdicts. But behind those structures is a human truth. Annabel Rook was not killed because a relationship ended. She was killed because the man who claimed to love her could not tolerate her freedom, because that meant he had lost control of his possession. Her work with vulnerable women and children should not be misread as irony. It should be read as a warning. Domestic abuse does not happen only to those who innately appear to be vulnerable women, or to those who lack knowledge. It happens where perpetrators choose coercion, domination, and where victims are made to be responsible for managing that danger, and where the public still misunderstands coercive control as conflict. Any person can end up being the victim of a domestic abuse perpetrator. That includes police officers, prosecutors, judges, social workers, refuge workers, nurses, doctors, you name it. This is the type of offence that is pervasive across all walks of life and levels and echelons within society. Annabelle's work with vulnerable women didn't protect her. Didn't mean that she could spot someone who was manipulating her in the first 5 minutes of a relationship and walk the other way. And the reason for that is that domestic abuse perpetrators are really good at wearing a mask of respectability and normality for long enough to get their hooks into the person that they're after. And it's only once they have a particular level of commitment that they then move on to showing who they really are. The law can convict, the justice system can sentence. The law can name aggravating features. Judges can impose life imprisonment. But prevention of this type of offence requires earlier recognition by the victim, by friends, by families, by professionals, by police, by prosecutors, by courts, and by communities. Professor Monckton-Smith's timeline matters because it tells us that there are opportunities to intervene before stage 8, which is the homicide, before the courtroom, before the life sentence, before the victim becomes a name read aloud in grief in the House of Commons for each year. Annabel Rook was described as joyful, altruistic, funny, compassionate, and powerful. She helped women find their voices in court in circumstances where they had been victimised. In court, after her death, the evidence gave her back a voice of another kind. Her messages, her notes, her fears, her hopes, and the testimony of those people who loved her. The jury was sure. They called it murder. The sentence was life. And the lesson for all of us is that domestic abuse is not private. It's not unpredictable, and it's not inevitable. It is patterned, it is dangerous, and it must be seen before it becomes fatal. So let's just talk before we close for the day about the key risk factors for homicide. These are stalking behaviours, breaches of court orders, talking about death in any context, non-fatal strangulation or suffocation, because any man who puts his hands around your neck or across your mouth is capable and has a much higher likelihood of killing you, because that's what's going through his mind in that moment. You don't place your hands around someone's neck and squeeze thinking, I love this person, I'm going to buy her roses tomorrow. You do it when you're thinking, I want to kill you. How dare you not follow my rules? And things along those lines. The way to talk to women about this subject, if you suspect that there might be domestic abuse in their relationship, is to ask what Professor Monckton-Smith calls what-if questions, which look to uncover the 3 C's of controlling and coercive behaviour in relationships. Those 3 C's are control, that's the rules and the monitoring that are in place. The challenge is the person picked up on for not complying with those rules. And the consequence, what happens if a person breaks those rules? So what questions can we ask? What would happen if you came home late? If the answer is, he'd gone mad, then you know that there is a rule with a challenge and a consequence. Other examples of what-if questions would be, what would happen if you wore revealing clothes, changed the pin on your phone, didn't let him look at your phone, watched a live stream on YouTube with a man that had no top on? Yes, that does come from a specific case. Friended a male on social media, went out with your friends without telling him, didn't answer your phone to him straight away, didn't reply to his texts, went to see your mum or siblings for a weekend without him. So those types of questions, what they do is they encourage the victim, the person that you're worried about, to self-reflect. And often what they do is they slowly start to unlock how many rules there are that they are complying with for fear of the consequences, either that they've already experienced or that they have been led to fear. If a person does disclose that domestic abuse is happening, your role is to be everything that the perpetrator is not. So that includes trustworthy, reliable, consistent, non-judgmental, safe, validating. And if we are really looking at not just domestic abuse within a relationship, but the risk of homicide within that relationship, 3 questions that increase your risk of being killed by 900% by your partner, if you answer yes to them, is there control? Has there been previous violence, especially if that includes strangulation or suffocation? Has there been a separation? If you answer yes to those 3 questions, 900% more likely to be killed by that person. So my final point of reflection is, please keep your eyes open, your ears open. Observe what is happening to the people around you, any changes in their behaviour, any nuances that suggest that something might not be right. If it's something that concerns you to the point that you are worried that somebody is at risk of homicide, then you need to report it. But outside of that, follow those steps that we've talked about. Be there for the person. Do not let A domestic abuse perpetrator used one of their most valuable tools, which is to isolate the victim from the people around them that can offer support. Don't be the person who turns their back. Be the one who stays regardless. Doesn't matter how many times the perpetrator tries to put you off coming into the house, tries to make it difficult for you to be there as a friend. Stay. Be available. Be a place of safety. On that note, just remains for me to say, look after yourself, look after each other, and I'll see you next time.